The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, October 20th, 2021. If you enjoy this podcast, you should check out our newsletter, an often irreverent take on recent Court of Appeals opinions, which we publish every Friday. And please check out our sister podcast, the documentary series, Bound by Oath. Is a forest a place of religious worship? That's not a question in either of the cases we'll be discussing today, but it would be the result of them if they made it. Trees have seemed worthy of worship in the past, at least for some. Celtic Druids famously venerated oak trees and held sacred rituals in oak tree groves. At least that's what my study of the Asterix books tells me. But even the Druids sometimes had to cut down trees. And when they did, I'm pretty sure they didn't have to get a permit and propose a plan to replace them. After all, the Druids were political leaders as well. However, a Michigan developer lacked that political power and therefore had to turn to the federal courts. We're going to hear about that story from someone who may not be a tree watcher, but definitely is a bird watcher. And without trees, the birds would be having a pretty rough time out there. Thus, we've invited on IJ's resident ornithologist and senior attorney, Wesley Hottot, to discuss this Sixth Circuit case with us. Welcome, Wesley.
Hi, Anthony. Seems like you're in fine fiddle today.
Well, as fiddle as our feathered friends. I guess we'll hear more about that in a little bit. Now, if a group of Druids left their oak trees behind, manned a few tables on the sidewalk, and handed out pamphlets criticizing the Chinese Communist Party, would the tables be a place of religious worship? Well, swap Druids for Falun Gong practitioners, and you get a very unusual case from the Second Circuit interpreting the Freedom of Access to Clinics Entrances Act. And not only was the court asked to define a place of religious worship, but also whether the activity the case concerned affected interstate commerce. IJ Law and Liberty fellow Dan Rankin joins us for the first time on Short Circuit to bring the news from the sidewalks of New York. Welcome, Dan.
Thank you. It's a pleasure to be here, Anthony.
Well, Wesley, if George Washington cut down a cherry tree in the township of Canton, Michigan, would he have to replant it? And more, maybe appropriately, what birds would be living in the tree?
Well, I don't know for sure where Canton is, but I think it might be the breeding grounds of the Kirtland's warbler, one of North America's most rare. Almost disappeared when extinct, but through some serious dedication to jack pine forest in upper Michigan, the Kirtland's is now exploding in population and can be found as far away as New York City's Central Park. So a real conservation success story.
That's wonderful news.
I'm sure it's one that involved partnerships between private landowners who, through money or through persuasion, were convinced to donate their land for the good of the cause. But private landowners sometimes don't want to do that, right? And in some places, like Canton, you have to get a permit before you can cut down trees on private land. I think that's true here in Seattle, if I'm not mistaken. But the conditions in Canton are quite restrictive. This case that I'm going to tell you about the conditions in is FP Development LLC versus the Charter Township of Canton. It's a Sixth Circuit case that was decided just last week, October 13th of this year. And FP Development is a real estate holding company. It was next door to some sort of manufacturing business and had lined up this additional parcel that it wanted to buy and then divide. It did that and realized that on some of the land it had purchased, there was a drainage problem, which was a town-built drainage ditch filled with tree limbs and detritus and such that was causing water to back up on their land. And so they asked Canton to do something about it, and Canton refused. And so instead, they hired a landscaping company to come out and clear out the drainage ditch, allow the water to move as it was intended to. And in the process, they cut down some 150 trees. And Canton then used their permitting statute as a stick, it says early in the opinion, rather than the carrot that you might see in land conservation projects where the government will pay someone to keep trees up. And the stick involved a $47,000 payment into the township's tree planting fund, or the replanting of some 185 trees, because some of the trees that they'd cut down in the process were so-called landmark trees, a unique species, or a tree that was the largest tree in an area. And this is a very interesting takings case with some interesting side notes in the court's decision. The panel affirmed the district court's decision on a Nolan-Dolan style taking. Now, listeners may or may not know that this is a sort of subset of takings jurisprudence that says that the government can sometimes take your property and thus owe you just compensation in situations where they've imposed conditions on the property such that you're losing some of its value. It's amazing. As we're sitting here, I can see a hermit thrush just outside my window, Anthony, and that's not a normal visitor here.
Oh, that's great news.
But back to trees. So this real estate holding company, represented by our friend Chance Weldon, former IJ summer clerk, and then a brief employee here before he worked at the Texas Public Policy Foundation. He brought this case on behalf of the development company, and the Sixth Circuit affirms the district court's Nolan-Dolan ruling and says, in fact, this has got to go back down and you've got to determine just compensation. So that pretty much is going to wipe out the penalty, the $47,000 penalty, or the obligation to rebuild these trees. One thing the court points out is that the city didn't even take into account the value to the environment and the community that it got from this company clearing out the drainage ditch on its own dime. And so, that at least should be considered, they say, in deciding what an appropriate division of the responsibility here is. So, that's a pretty rare win, if I'm not mistaken, under Nolan-Dolan. Anthony might know better than me, but I have not seen many cases saying that applied.
I don't know the data. I'm sure others have done that effort, but it is pretty rare. Yeah.
Yeah. The bottom line is you don't normally win your takings case based on these kinds of conditions on the use of your private land. And, I was also very interested in a kind of a side at the end. FP Development had brought an excessive fines claim as well, saying that, in light of the things we talked about, they cleared out this drainage ditch when the township wouldn't do it. They'd taken down some trees. I'm sure there were factual disputes about like whether they were viable trees or rotten trees or trees that were contributing to the problem in the drainage ditch. All of that's going to have to get sorted out in the district court. But one of the things that they said is we've got a viable excessive fines claim here because we're being punished. We're being punished with the stick for having cut down these trees and done the civic good of clearing the drainage ditch. And the court says, you're not being punished. This is remedial. And I bring it up because I think that this is one of the most interesting developing areas of Bill of Rights litigation right now. It's unspoken, but it's in light of the Supreme Court's decision in Thames versus Indiana.
Which you might have something to do with, I believe.
That's true. I did help with that litigation.
He argued the case, ladies and gentlemen. But anyway.
Thank you. And the Thames ruling really reignited interest in the excessive fines clause. I mean, its holding is pretty unremarkable that the excessive fines clause applies to the states. But the opinion goes through some of the history of the clause and has raised a lot of questions about other situations that it might apply to. And what you see developing in the circuit courts right now is this discussion of what is a fine. We know from previous Supreme Court cases like Austin and Bajikagian that a fine has to be at least partially punitive. But the court has emphasized that, fines, penalties, they often serve many different purposes. They serve a deterrent purpose. They might serve a remedial purpose in part. But if any of what the government is trying to do is punish someone and extract some of their wealth, the excessive fines clause should apply. And what you see district courts and the circuit courts doing now is coming up with more and more interesting ways of defining remedial in order to avoid the implications of saying that things are fines. There's a case that just came out of the New Jersey Supreme Court that is being appealed to SCOTUS now, where they said that the forfeiture of a man's entire state pension over 40 years of state employment was not a fine, but rather they redefined what it was to say that it wasn't even his property because he'd done something bad while he was in state employment, and getting state benefits requires you to serve honorably. Therefore, it's not even property that could be subject to any constitutional protections. So the bottom line is there's more and more tortured reasoning going out there. It's usually going in favor of the government to say that things that are clearly at least partially punitive aren't because of what it might raise. And if you've got any case along those lines, please send it my way. I know they're looking for amici in the New Jersey case. And I think that we might see, in addition to some interesting developing tree law and maybe bird law, we're going to see some interesting excessive fines clause law over the next decade.
Yeah, no, I'm glad you brought this excessive fines clause issue up, Wesley, because it caught my eye as well. It seems a bit troublesome to me that the common theme here, I feel like, is so long as the legislature just basically labels the fine as remedial, then we have to basically forego the excessive fines clause analysis. And the same can be said with administrative fines that are routinely labeled by Congress and state legislatures as civil. Whenever that happens, individuals have to forego the panoply of constitutional protections that are ordinarily afforded to criminal defendants. And so it just seems like an area of the law where it really, really just depends on what Congress feels like labeling it. And the courts just kind of have to throw up their hands saying, okay, well, this is what we're going to do. And if it's remedial, then no excessive fines clause scrutiny. And I think it's pretty telling here in the court's footnote, in footnote 6, the last one, that the tree ordinance not only has a $500 fine, but also has a punishment of 90 days imprisonment. So it's just like, okay, well, you can label this as remedial, but we also have jail time following the violation of this law. And I find that a bit troublesome.
Yeah, ain't no jail going to hold Paul Bunyan. But yeah, this is one of the most frustrating things about the law, ladies and gentlemen, is the tendency for semantics to overwhelm, for form to overwhelm function. Sure, one man's fine might be another man's remediation, but we're not playing linguistic games here. We're trying to enforce a constitutional principle. And as we've insisted at every level of the American judicial system, this is not a labeling game. The legislature doesn't get to define for constitutional purposes what a fine is. They can call whatever they want to call the penalty in their law. They could call it a tax on the tooth fairy. If it is partially punitive, then the Constitution requires it to be assessed as a fine. And courts probably being misguided by lawyers, are constantly taken in by this linguistic game when it's actually not that hard given the constitutional test. This is one of the things that's pretty easy to apply if any of the things that the government is trying to do, regardless of its label, it is a fine for purposes of the Eighth Amendment. And I don't know why we're so afraid of that, because the Eighth Amendment only prohibits excessive fines, not all fines.
One thing I couldn't quite tell from the opinion is what the money that the developer is saying is a fine, was that going to go directly into planting trees, or was it a little nebulous?
It was going into the township's tree fund. And, one of the more reasonable things that was going on here is that you were given a choice. You could either pay to mitigate whatever damage you had caused in the eyes of township officials. You could just do that yourself by hiring like a certified arborist. Or if you didn't want to do that, you could just give them a bunch of money based on a fixed framework. And it was about $47,000. Who knows what it would have cost for them to hire someone to do it. I think for this particular real estate developer, it's probably less about the dollar figure and more about the principle that, he's trying to be a good land steward, even talk to the city about the project and still got hit with a penalty. I could see why a man, particularly one represented by a pro bono project like TPPF, would want to litigate that.
Mm-hmm. One last point I thought was interesting is they apply the Nolan-Dolan test. They say why there were other kinds of takings claims made, such as a regulatory taking claim.
Yes.
People get confused by this, but the Nolan-Dolan kind of taking exaction is actually different than a regulatory taking. And so they made a regulatory taking claim, but the court says, well, we don't have to address that. But then the Judge Bush also just kind of starts musing about, well, according to the original meaning of the takings clause, this might not even have been a taking at the founding of the country, but it might have been a taking when the 14th Amendment was adopted, which is something we've talked about on previous podcasts of, should you look at the original meaning of one era or another when you're talking about the 14th Amendment? But we're not going to get into that because, we're just an appellate court, which is something courts of appeals are doing a bit more than they used to. He had a lot of citations, which I appreciate. I know there's one former judge and one current judge on the Seventh Circuit that often do this and don't even have citations. So I appreciate those citations. But I thought that was, I don't know if it's a sign of things to come or if it was just some interesting musing.
Yeah, they really do seem to spend a lot of time flagging issues for either litigation or for future courts to take up. And I was curious, Anthony, do you know if this is accurate? On page 7 of the opinion, the court writes that general land regulation was commonplace in colonial America. And that just seems like a dubious proposition that might need more than a few citations. I mean, I wonder if we even really know much about land use in colonial America, land use regulations.
Well, I know that to a point that is true, that there was some land use. They mentioned the Pine Tree Act, which is kind of neat. Which I know I think got the colonists of Maine, which was then part of Massachusetts, riled up at one point. And sometimes you see a flag that has a pine tree on it, and that was actually a kind of a flag from the Revolutionary days about resistance to, the equivalent of the DNR today, you might say, in the form of the British. But overall, was it like today? I mean, of course not. They didn't have zoning in anything like what we would call it today or other land use regulations. If people are interested, I think there's a number of scholars who have written about that. One friend of the podcast, Molly Brady, who was on about a year ago on similar subjects. You could check out some of her work. But yeah, I think that's being a little too cute to say that there was some regulation at that time and therefore the Fifth Amendment, doesn't apply. Maybe the Fifth Amendment doesn't apply, but that's not doing all the work. Well, some people who were doing a lot of work were the Falun Gong protesters on the sidewalks of New York. They it seems hard to know exactly what was going on, but there's a lot of details in this opinion about some very egregious conduct, it seems, that may have been conducted by a few folks who were then sued, but it turns out unsuccessfully. So, Dan, could you tell us a bit about what's going on here with these Chinese Americans on either side of this dispute in the Second Circuit?
Yeah, this case is a bit of a wild ride, Anthony. The case style is Zhang. Well, a quick preface here. I'm going to be mispronouncing a lot of things, a lot of names in this case, so just forgive me for that. The case is Zhang Jingrong and others versus the Chinese Anti-Cult World Alliance. It's on an interlocutory appeal to the Second Circuit. And it involves a federal law called the Freedom of Access to Clinic Entrances Act. And I think the acronym is FACE. And there's a provision in that law, Section 248A2, that makes it unlawful to intentionally injure, intimidate, or interfere with a person exercising their religion at, quote unquote, a place of religious worship. And the question on this appeal is, what does that phrase mean? What does a place of religious worship mean? Because the statute does not define it, so the Second Circuit is going to have to do that. And the plaintiffs here are people who engage in the spiritual practice of Falun Gong, which is a spiritual practice that originated in China around the 1990s. And this religion basically involves a practice known as cultivation that entails meditation, physical exercises, and just general religious study of teachings. Importantly here, unlike many other religions, Falun Gong lacks a more formal building of worship, like a church or a synagogue, and they instead gather at spiritual centers and even in their homes to do some of these things. And the plaintiffs here, 13 of them, they're all members of the Falun Gong, and they gather in Queens, New York at a spiritual center and do their meditation and exercises. But apart from that, they end up going to downtown Queens, New York, and they set up various tables on the sidewalk. And what they do at these tables is pretty important. They pass out posters and literature to random passersby, and the material just basically explains what Falun Gong is, but most of it is just really critical of the Chinese government. And the reason for that is that Falun Gong members allege the Chinese government persecutes them, tortures them, imprisons them, and even notably here, another heinous thing, which is harvesting the organs of Falun Gong members. And from what I could tell from the opinion, the posters they were passing out on the sidewalk actually depicted the organ harvesting. So I would imagine an unsuspecting passerby would be rather alarmed from getting one of these posters. But anyway, here's where the defendants come in. The defendants are members of the Chinese Anti-Cult World Alliance, and these guys don't like the religion of Falun Gong. They think it espouses some troubling views, like not taking medication for illnesses and things like that. And there's just a deep-seated antipathy between these two groups, which ultimately culminated in the events giving rise to this lawsuit. The plaintiffs allege the defendants began flipping their tables on the sidewalk and began verbally abusing them and attacking them. And this resulted in a federal lawsuit involving all kinds of claims like assault and battery. But one of those included a claim under the statute I had mentioned earlier, the Freedom of Access to Clinic Entrances Act. And it provides a cause of action for anyone who's intimidated or assaulted at their place of religious worship. So they end up moving for the parties end up filing cross motions for summary judgment, and the district court has a hearing on it. And it ultimately results in the district courts issuing two separate orders. The first order dealt with the FACE statutory claim here. It said that these tables were indeed places of religious worship for Falun Gong members. And it did not matter, according to the district court, and what the defendants argued, that these tables were not used primarily for religious worship. It was sufficient, I guess, in the district court's view that that some incidental or some partial worship had taken place at the tables. But interestingly, there's also a second order here addressing the defendant's alternative argument, which is that this statute, the defendants argue, exceeds Congress's power under the Commerce Clause. And I think any 1L in constitutional law might have their eyebrows raised because, we know that it's almost inevitable that your lawsuit under the Commerce Clause might be unsuccessful given how expansive and robust that clause is. And in rejecting the defendant's argument for that claim, the district court had noted that places of religious worship are economic in nature and involve substantial revenue collection and things of that sort. So this ends up going to the Second Circuit on an interlocutory appeal. The district court had certified the questions on appeal because it had anticipated a pretty long trial with various issues and parties. But the only issue the Second Circuit here dealt with on appeal was the meaning of a religious place of worship and whether those tables qualify. The Second Circuit had concluded that phrase was ambiguous. And as Wesley alluded to earlier, there's a lot of linguistic play going on here, some of which I think is a bit justified. But the Second Circuit ends up finding it rather ambiguous and feeling compelled to consult the legislative history of this law. And in consulting the legislative history, it found a joint conference report saying that Congress really intended that the place of worship be used primarily for worship. And so the Second Circuit finds that pretty dispositive. And it had no trouble applying that interpretation to the facts at hand here. It said that these tables, as the plaintiffs had essentially conceded in the evidentiary hearing at the district court, that these tables were primarily used for political protest. And there was very little, if any, worship going on. There wasn't any kind of a testimony regarding the plaintiffs doing meditation or physical exercises near the tables. And so the Second Circuit ultimately reverses the district court on this issue and unfortunately did not reach the defendant's alternative argument under the Commerce Clause. But before I get y'all's thoughts on the majority opinion, I thought the Second Circuit had a pretty good example here at the end of the opinion to illustrate its holding. It says, take for example football players on a football field who go and pray on the field. And as listeners probably know, that was also a case over in the Ninth Circuit.
A short circuit case twice.
Really? Okay. Yeah, that sounds right. That's probably where I heard it from. I'm not quite sure what the ultimate disposition of that case was. I'm sure you do, Anthony. But you look at those players in the football field, and they probably wouldn't regard the football field as their place of worship, despite kind of engaging in these worship-like activities like prayer. And I thought that was a pretty good common sense reading of the statute. I didn't think the quick knee jerk to the legislative history was all that compelling in my opinion, but I think it reached the right result nonetheless. But I guess the concurrence, I will say, did address the Commerce Clause issue, but like I said, I would maybe get any takes from y'all on the merits of the majority opinion here.
Yeah, totally. I mean, it seems obvious that tabling, although it might be religious in character, it might be expression of your religiosity, that it's not using your house of worship. Now, I think I did read that like the Falun Gong apparently, do they or do they not have traditional houses of worship? I thought they didn't.
The opinion says they do not have traditional houses of worship.
But they have like a spiritual center, which I take to maybe like a offices or, a community center kind of. anything.
Yeah, I mean, I would think that courts in interpreting this law would have to be careful to look at it in the context of the religion, because it's fairly easy for us to say in the Western tradition that a Catholic church has a place of worship. It would be the church. It might be harder to say where a Buddhist place of worship is, and the First Amendment compels us to be neutral toward religion in these things. So, but in this particular application, it seems correct that what they were doing was protesting, not engaging in worship at their house of worship, whatever that might be.
Yeah, it seemed like they had two strikes against them. One is it wasn't a place that's really, I mean, it's a public sidewalk. It's kind of the hardest facts. And then two, that really it was political, not religious, what they were doing. But I mean, you're right, Wesley, we do have to be careful because, a lot of small churches, even today, people meet in their homes. I know like Quaker groups sometimes get together and meet in each other's homes. The early Christian church didn't really have churches. They actually met in their homes for the first couple of 100 years of Christianity. So, I think maybe Congress didn't mean a house, but that would be a much closer case if it was like a house where these people usually went. Like maybe they would win on that. But a public sidewalk, it's just it's not going to work for them. I mean, I think it is a little odd. I'm guessing there's probably attorney's fees or something here why they brought this claim and not just normal assault charges, because that's really what is going on here.
I was going to ask Dan, why do you think that this is a federal case?
My best guess, as Anthony said, would be the attorney's fees, because it seems like most of the claims here are really just kind of your traditional state law claims, like assault, battery. I think there are claims of like defamation and intentional infliction of emotional distress. And the strange part about this too, procedurally, was that neither party was prepared to move for summary judgment on the federal claim under the FACE statute, and the district court had sua sponte ordered supplemental briefing on that issue. So I don't know. I could only just speculate as to why they chose federal court, because it seemed mostly involved with the state law claims.
And there's nothing in the opinion. So this is something, I was thinking about reading the opinion, knowing what's outside the opinion, is there's nothing in the opinion about the people who were flipping these tables over, that they are formally connected with the Chinese government in some way. I mean, that's only just speculation we'd have about why they're actually doing this?
I think it's alleged, right? They say that there's some connection to the Chinese embassy.
I see. Okay.
I think the plaintiffs allege that the Chinese government subsidizes this particular group, the Chinese Anti-Cult World Alliance.
And maybe that could be why they're trying to make a federal case out of it in some way. No, I don't think, that's probably how they try and get a jurisdictional hook, because it seems like that wasn't even argued. But it seems like something that Congress is going to do has more to do with that situation than if it's just a couple of rival gangs or people who just don't like each other's religion.
Back to this opinion here in the concurrence. Like I said, the majority did not address the defendant's alternative argument that Congress had exceeded its commerce powers. The majority said it didn't need to address that issue because it ruled for the defendants on the statutory issue. But the concurrence said, I would address this issue as well. And he agreed with, I think it was Judge Walker, he agreed with the defendants that Congress had actually exceeded its power here. And to do a little table setting of what this concurrence is all about, we kind of need to backtrack just slightly, maybe all the way back to 1903 to McCulloch versus Maryland, that old chestnut, where you can see where the Commerce Clause and the Necessary and Proper Clause are kind of conjoined together to give Congress this really capacious source of power. But the modern doctrine, as we know it, can really be traced back to the New Deal. With cases like United States versus Darby and Wickard versus Filburn, both of which established, as our listeners probably know, this substantial effects test and the aggregation principle. But it's important to know here that in the late 1990s and in the early 2000s, there was a bit of a retrenchment in the Commerce Clause jurisprudence with two cases, United States versus Lopez and United States versus Morrison, that where the Supreme Court really tried to draw a bright line between economic activity and non-economic activity. The latter, even if it does have a substantial effect on commerce, cannot be rightfully regulated by Congress. And that's what the concurrence really principally relies on here, those pair of cases, to really kind of reinforce the principle that Congress does not have the general police powers that states ordinarily retain. And here, I think I agree with the concurrence that, whatever activity is being regulated here, whether it be religious worship or the right to be free from violence as you're worshiping, none of that sounds commercial to me. None of that sounds inherently economic, and I think that's pretty self-evident. I won't go into the full explanation as to what the concurrence did, but one thing puzzling me, and I was going to get y'all's takes on it, was it didn't seem obvious to me how the concurrence could have reached this issue if it agreed with the majority on the statutory claim. It seemed to me more of a gratuitous concurrence and just kind of opining on the Commerce Clause. But that's just how I read it.
Yeah, I think it's like what Anthony was talking about before, that we see circuit court judges more and more going out of their way to flag issues that from their perspective are of consequence. And there might be a variety of reasons why they do it. One of as like former clerks probably know, sometimes it's to plant a seed that you can then cite later as the time that you pointed out or predicted that this was going to be an issue. I think more charitably, perhaps it's judges trying to be helpful to bench and bar by providing more context, going out of their way to do extra work, writing a concurrence that doesn't have to be there to let people know that there's this issue floating out there. I think it's right to, Judge Walker's right to question whether the Commerce Clause allows this kind of regulation. I wonder how far he would take the principle. I can imagine circumstances that sound closer to what I perceive as the Commerce Clause line, right? Even under this statute, where if you had some sort of interstate group, let's say the Ku Klux Klan, that was targeting places of worship for whatever reason and burning them down, that sounds more like something that Congress could regulate. Now, set to the side the fact that there are other statutes that regulate that, like the Civil Rights Act, et cetera. But I just wonder where Judge Walker would come down in a case like that. And maybe he doesn't know and is just saying that, and I agree with him, that under these circumstances, Congress doesn't have the power to take over state and local regulation of common law torts, like people roughing you up, with the possible exception of when, Prime Minister Erdogan's goons attack protesters in D.C. or something like that. If you're not on federal property, I don't know that the federal government has any real dog in that fight.
Yeah, I see that. I see this concurrence as, a more natural thing for a judge to kind of muse about, and especially because it was raised by the parties and argued and all that. I think for doctrinally, it is an interesting, the fact scenario here is an interesting kind of piece between Morrison, which was really a law about sexual assaults, which is about as bad a thing as it is, which is about as far away as you can say from an economic transaction as you can get. And then on the other side, the more obvious, say, economic substantial effects scenarios that have been found constitutional for a long time. What was going on these sidewalks? Was that closer to something like a normal non-economic crime? Yeah, it does seem like that. But would other kinds of blocking of places of worship, especially if it's like a large church or mosque that, has a large budget and impacts the local economy and local leaders go there or whatever you want to do. I mean, under original interpretation of the Commerce Clause, I think that probably doesn't matter. But under that case law, it could be a much more on the an as applied kind of argument. But Wesley raised one thing where I think it's interesting that Judge Walker didn't go there, and I'm not saying he should have, and I'm sure the parties probably didn't even talk about this, but I could see this being justified, unlike what the court ruled in U.S. versus Morrison. I could see this being justified under the 14th Amendment and Congress's powers under the 14th Amendment in trying to protect religious freedom. Now, you need state action, and this act seems to apply just any old Tom, Dick, or Harry who tries to blockade a place of religious worship. But whatever this group was doing, especially if there was evidence it was tied in with a foreign government, it seems much more like, the KKK or an organized group of folks who are in some way protected by state action, even if it's a foreign state in this case, than, just a private citizen. So, in future litigation about this, if the Commerce Clause comes up, I could see maybe that being in the mix as well. But that might just be kind of specific to the weird goings on the sidewalks of New York.
I mean, I think it should surprise no one that three attorneys can muse about all kinds of hypotheticals under modern Commerce Clause jurisprudence, because
that sounds like a Court of Appeals panel.
It does.
Three attorneys musing.
I mean, I will always sign up for your moot court if it's about the Commerce Clause, because it's an opportunity for me to sit there and make jokes that are actually legitimate questions.
Well, that's also always true. Also true of rational basis analysis as well.
Yeah. And I'll always come to those moots too.
Yep. So I'm happy that both of you came to make some jokes today and to talk about the Commerce Clause. No rational basis, maybe thankfully for once, but I'm sure we'll get to that soon. So thank you, Dan, for coming on for your first visit. Thank you, Wesley, for the ornithological updates that we're all glad we have. And I hope he inspired all of you to pick up your binoculars and look out the window. And also, I hope that all of you will use this as an excuse to get engaged.